Okay, it looks like everybody is getting entered into the Zoom room. Good evening, everybody, and welcome to another episode of Family Matters with Judge Philip Smith. We appreciate you joining us tonight. We want to say a special thank you to or recognize Judge Amanda McClendon, who is with us here tonight. And I also see Carolyn Pipus, who's with us tonight as well. Thank you, Carolyn, for being here, one of our night court commissioners. So anyhow, we are going to get started. We apologize for the delay and being a little bit late this evening. We had some technical difficulties, but we are here and ready to roll now. So I will say good evening, Judge Smith.
Good evening. How are you, Steph?
Well, I'm pretty good. How about you?
I'm doing great. And guys, I've got to make an announcement about Stephanie. Stephanie is the newest member of the faculty of the National School of Law. Congratulations, Stephanie.
Yay, thank you. It's so funny because when people find that out, they're like, what are you teaching? And I'm like, I only know one thing, like domestic relations. Well, I know more than that, but that's what I'm more comfortable
with. And you are a welcome member of the faculty. You're going to do a great job, and look forward to working with you on that.
Yeah, I'm so excited. I'm just excited to finally be a part of the NSL community. I mean, there are so many great lawyers and judges and whatnot that have come from NSL, and I've always kind of been a little envious of that. I'm a proud UT Law grad, but I do realize NSL really has a special place in this community, so I'm really honored to be able to call myself part of that family. So yeah, it's exciting. So I want to talk a little bit about you. You've been really busy working on a CLE that's coming up next month it's very near and dear to you. So I want to talk a little bit about that to let everybody know what we've got going on so that they know that this is really something different and something they need to try to be in.
Well, unfortunately, I mean, it comes about because of problems we're having in Davidson County. We have had either 9 or 10 domestic homicides already this year, and we're going to break a record this year, and that's not a good record, of the most domestic violence homicides in the city. And we got to do something about it, and there is just no absolutely right or wrong answer. So I thought we needed to start educating divorce lawyers, lawyers that work in the domestic arena, as to red flags and things that they can pick up when they're representing their clients. And this is what it is really geared to. We're going to have Diane Lance from the Family Justice Center, and we're going to have a panel discussion of Judge Robinson, Judge Philip Robinson, Judge or Special Master Dana Ballinger, and Judge Allegra Walker. I'm actually going to be the moderator, so I've got the easy job this time. We're going to have that. Then we're going to have Rob Riley come and talk about TLAP and some of the services that are available for lawyers, and particularly, the counseling for vicarious trauma. That's something that when you work in this area, particularly in the abuse or the domestic violence area, you may need that at some point in time. You may need some counseling on that. Vicarious trauma is real, and TLAP is an organization we look at to treat people with substance abuse problems, but it's a lot more than that. And I want to make the lawyers aware of what is available to them when they need it. And then finally, this is really special to me. I'm gonna have one of my best friends, grew up with me in Donaldson, went to McGavock. I lived with him in college. He is a retired assistant director from the United States Secret Service. He actually protected 4 presidents, 4, I think, maybe 5, but at least 4. And retired a few years ago as an assistant director. I don't think there's anybody better to talk to lawyers about their own personal safety. And with the environment we're experiencing now post-COVID, we're seeing some unusual behavior. And lawyers have to remember that they can be targets. And as far as the legal profession, domestic lawyers being injured or killed by either their clients or the other side, that is one of the hotspot areas, if not maybe the most dangerous area to practice. So I think it's really beneficial to lawyers to come and let's cover these issues. And one thing I want to encourage, Stephanie, is I want people to forward questions before that seminar. It is on August the 12th. That is a Thursday night. It's going to be in the A.A. Birch Jury Assembly Room. We've only got so much room, but it's going to be from, I believe, 4 to 6. And we're going to get you out of there early, but it's going to be a really good CLE. It's going to be a CLE that I think that all divorce lawyers can benefit from. So I hope you can attend. And it's being sponsored by the National Bar Association. And I guarantee a good CLE for you. So thank you for mentioning that.
Absolutely. So I believe it's 2 general hours, as you said, in conjunction with the Nashville Bar Association. So you can sign up and get more information on their website. I do have a question. Will the seminar also be virtual? At this point, my understanding is that we are going to be able to seat a good number of people in that jury assembly room in the Birch building. And so our goal is to have it in person. We really want this to have a lot of punch to it. We want people to get together and see each other. Like, this will be the first probably rather large gathering of the domestic bar since kind of, I don't want to say coming out of COVID, because I don't know that we're there yet, but since we've had a lot of restrictions lifted. So it is our goal to keep it in person. Now, if we sell out, then I think, Judge, you mentioned that we will look at potentially doing it virtual at that point.
We will. And, I think the National Bar Association is going to actually record it. So it may be available at a later date also.
Okay.
But really looking forward to it. Hope everybody can attend.
Yeah. All right. So it's been since May. Last time we were here in May, we took the month of June off so that I could go out west in a 40-foot RV and do my thing for a week or so. So we're back at it now. Last time we actually had the topic of child support and alimony, and I think we underestimated how much we could get involved with child support and never really touched on alimony. And so tonight is just kind of a continuation from that to truly focus on alimony. So I just want to jump right into alimony and the basics of alimony for anybody who may be on here that are really kind of unfamiliar with alimony. And so I think it's important, first of all, to talk about, what is the purpose of alimony and what types of alimony is available for people.
Well, let me say, Steph, I have lost you. Can you give me just a second? Can you still see me?
I see and hear you.
Okay, well, I'm trying to figure out what happened.
You are Judge Smith, not Judge Robinson. You're not technically challenged, Judge.
Judge Robinson is often known here, so I hope he can join us later on. Let's talk about alimony. That is probably one of the most misunderstood areas in the area of domestic relations or in a divorce case. And there's a lot of discretion with the court in regard to alimony. We got 4 types of alimony: transitional alimony, alimony in solido, rehabilitative alimony, and as one of my students once said, and I see Ryan Davis on here, it wasn't his class, it was a couple classes before, but described alimony in futuro as the Mac Daddy of alimony. And it's the one that when you're representing an obligor parent, it's the one that you're always fearful of. And it's the one that your client does not want. But those are the four categories of alimony in the state of Tennessee. Now, for many, many years, it was just alimony and solido and in futuro alimony. And back in the 80s, the legislature came up with rehabilitative alimony. And obviously that is used when a spouse can be rehabilitated, to provide for the same or similar standard of living that she enjoyed or he enjoyed with the spouse during the marriage. And rehabilitative alimony is still around, but was kind of the go-to form of alimony for a long time. Well, as the case law developed, we started noticing, some holes in the rehabilitative alimony. One, if the spouse couldn't be rehabilitated and it was not an appropriate case for in futuro alimony, no alimony was awarded. And I believe it was the case of Aaron versus Aaron, a case that was authored by Justice A.A. Birch. And he used the term in that decision, closing in money. And what he was saying is, this is not necessarily a form of alimony we have right now, but the legislature really needs to consider it because sometimes a spouse may need alimony for a very short time. Rehabilitation is not possible, but what you're doing is you're allowing that spouse to kind of adjust to the back to living a single life. And so the legislature has developed, I don't know, 15, 20 years ago, transitional alimony. And transitional alimony is probably now the form of alimony that actually gets used the most. There are some criteria on transitional alimony, such as it is non-modifiable unless it is agreed to by the parties in like a marital dissolution agreement. It is, and it's only modifiable to the extent that the parties have agreed it's modifiable. If they don't agree, it terminates upon death. Now, what's kind of unique about alimony and, transitional alimony is that the live-in lover statute is what it's often been referred to, and I still refer to it as that, even though it doesn't have to be a live-in lover. It applies to obviously modification of alimony and futuro, but it also applies in modification of transitional alimony cases. Now, the beauty of transitional alimony is the parties can actually agree to the terms of modification or termination. And so you've got a lot of flexibility with transitional alimony that you didn't have with rehabilitative alimony or either alimony and solido or in futuro alimony. So it's one that is used generally for a fairly short term. It can be used for a longer term, but generally for a shorter term. And like I say, we're seeing a lot of it used in marital dissolution agreements now. Rehabilitative alimony is still alive and well. And in order to use rehabilitative alimony, the spouse has to be rehabilitatable. And, have they had some education? With a few years of support, can they complete an education? Can they, work in an area that can, where they can provide for themselves in the future? And it's still a niche form of alimony, but transitional has supplanted it in a lot of ways. And you have to be able to be rehabilitated. Now, that is a tough decision that the court has to make. Is the spouse rehabilitatable? And if the answer is no, but it is an appropriate alimony case, you've got transitional for the closing in portion, or you've got in futuro to support the needy spouse until death or remarriage. And again, that is modifiable upon under the terms of the live-in lover statute. And it is also, it terminates upon the recipient spouse, their death or remarriage, or the death of the obligor spouse. Those are the automatic terminating factors. Again, we see it. It is probably next to alimony solido, probably the least used form of alimony at this point. You generally see it in long-term marriages. You see it where one spouse has contributed to the marriage by way of raising children, being a homemaker, things of this nature. And remember, under the statute, that has not always been the case, but under the statute now, the work that a spouse provides as a homemaker, as a parent to children, primary parent, stay-at-home parent, that is of equal dignity as being the main financial breadwinner in in a family situation. So there's certain parameters for alimony and futuro, and the other form we use is alimony and solido. The most common form of alimony solido is attorney's fees. When attorney's fees are awarded in a domestic case, divorce case, attorney's fees are generally awarded as alimony and solido. I tell students that, alimony and solido, don't forget about it. It is a good form of alimony to use. And you may have a situation that maybe it's truly potentially a rehabilitative case or a long-term transitional case. But if you've got a spouse that really wants to quantify what they're going to pay over a set amount of time, alimony and solido is a good form to use because it is non-modifiable. And you can, on the day of the divorce, determine what amount is owed in the future. And a lot of times in big money situations, that's very important to an obligor. The obligor is going to want to know what their exposure is over time. Remember, transitional alimony is by statute only modifiable if the parties agree or the court orders. The court can, attach contingencies to it too. Rehabilitative alimony is also modifiable, but there's certain hoops you have to jump through. And in alimony and futuro is only modifiable under the either the live-in lover statute or the traditional material, substantial and material change of circumstances standard. But alimony and solido, never modifiable. You can calculate from the day that the divorce is granted what an obligor is going to owe and what a recipient spouse is going to receive. And it doesn't matter what happens in the interim, it is non-modifiable. So those are the forms of alimony that we deal with, and think that's just a general history of alimony as it exists currently in the state of Tennessee.
Thank you for that. I certainly hope that members of the bar were taking notes, because that was a good lesson on alimony from the judge. Good information for people to have as you're looking and prepping for your cases. And yeah, I do want to emphasize how important or what a useful tool alimony and solido can be in cases, because it does limit the exposure of the person paying alimony, the obligor, and it also gives some assurance to the recipient of the alimony that they are going to get this sum certain over whatever period of time it may be paid, and they don't have to worry about being drugged back in court, or if somebody has, ideas or thoughts about getting remarried, none of that's going to matter. And so it's really like they can just go ahead and live their life and plan for what that looks like without having this alimony over their head. Now, obviously, that's not always possible, and in some cases, it's probably not the most appropriate form, but it certainly can be very helpful in cases that it is available. So absolutely, I want to talk a little bit about. We talk about these forms of alimony. What is the court really? Well, let me back up for one moment. You've given us 4 types of alimony. I have seen you order more than one form of alimony in a case. And I think that's something that a lot of people may not be aware of. Can you talk about that and how people can actually play with, alimony in that manner and have 2 forms of alimony in a case, either by agreement or what they may potentially expose themselves to at trial?
Yeah, there's a case that I want to say came out in the mid 90s, maybe early 90s, Crabtree versus Crabtree. And that was a case, Judge Mike Binkley was one of the lawyers on it, and Ed Yarborough was one of the other lawyers. And what they did in Crabtree was I believe it went all the way to the Supreme Court. I'm not exactly sure on that. But in Crabtree, excuse me, in Crabtree, the trial judge had awarded both rehabilitative alimony and alimony and futuro. And the appellate court said, no, you can't do that. And then a year or 2 later, the legislature got involved and changed the statute and said, yes, you can. Well, let's think about a situation where those 2 forms of alimony might be used. Obviously, you could have alimony and futuro, rehabilitative alimony or transitional alimony in a case with alimony solido, i.e. attorney's fees, can use those 2 forms. But you can also use it in a situation where there is a need to rehabilitate a spouse to a point. And you may actually have a higher rehabilitative alimony award. Maybe it is to allow a spouse to complete an education or maybe some additional training to get a job. But even in a best case scenario, that spouse is not going to be able to enjoy the same standard of living that they enjoyed during the marriage, or the standard of living that the obligor is going to enjoy after the divorce. So what you can do is order rehabilitative alimony for a period of time, and you can order alimony and futuro to accompany that award during the same period that it is running. And then once the period of rehabilitation has expired and the spouse has rehabilitated themselves to where they can provide for themselves, then you've got the alimony and futuro that will fulfill the difference in the standard of living that they're going to enjoy in the future versus under the statute, the standard of living they enjoyed during the marriage, or what the obligor's standard of living is going to be post-divorce. So that's an example of how you would want to use it. You could use a combination of other forms of alimony. A form of alimony solido by lump sum payment of money over, maybe at the time of the divorce. Deem it alimony and solido, and you still got the alimony and futuro to make up the difference. The one you're probably not going to see a lot used together is transitional alimony and alimony and futuro. And remember, transitional alimony is to close the gap. So it's really going to be kind of hard to come up with a scenario where you're going to have transitional alimony along with alimony and futuro or rehabilitative alimony. So it's great to be able to have those tools in your tool belt.
Mm-hmm. Absolutely.
And employers need to remember those tools are available.
They are absolutely available. I would want to suggest that they're more available at trial than judicial settlement conferences. I could see how that I could see how they would complicate things at judicial settlement conferences, but absolutely go for it at trial. Um, what are you predominantly looking for when you are analyzing the case for alimony? I mean, we definitely know the statute gives us several factors, but what is the court really honing in on? What are you truly looking at?
That's hard to say. It's and I go back to I guess a United States Supreme Court case, a case that Potter Stewart, former Justice Potter Stewart, um, authored, and it involved pornography, uh, and it was difficult to define pornography. I don't even know what the definition is, but Justice Stewart made the statement that, and it's a pretty famous statement. I know it when I see it, and you kind of get a feel over time for types of alimony, for the amount of alimony, and there is no bright line test, but we always start with the factors, and they're contained at TCA 36-5-121, and those factors are pretty clear in the statute. There are some factors that really mean more than others, but the primary two factors is the need. This is when you initially set alimony, is the need of the recipient spouse and the ability to pay by the obligor spouse. Those are the absolute, factors that you look at, much like you do in a temporary support issue. You start with what does a spouse need, and versus what an obligor can pay. Now, by the time you get to final hearing, litigants should have a plan for the future. In a temporary alimony or temporary support situation, we're trying to just maintain the status quo. But by the time you get to final hearing, people should have plans for the future. And what are those plans going to involve? What are they going to cost? Those are the things that you should have going into a final hearing. And you ought to, if you're requesting alimony, you ought to address in a trial brief each of those factors set forth in 36-5-121. You start with the form of alimony. You start with, need and ability to pay, standard of living, length of the marriage, et cetera. You go through each of those factors and try to convince the court of why the form you're requesting is appropriate and why the amount that you're requesting is appropriate. Now, if you're defending against an alimony award, you want to take exactly the opposite approach. And before you look at the contents of 36-5-121, you want to look at the marital estate. And is there income producing property that may be in the marital estate that can be divided to cut down the need for alimony? In other words, there may be some rental property involved, maybe several parcels of rental property. And you could divide that rental property in a way that gives an equal amount of the the rental property that generates income to the spouse, or a greater amount to the spouse. So the rental property is generating income. Yes, of course, it's got expenses with it, but if it's got net income and it is producing it monthly or weekly or whatever, that may help to alleviate the need for alimony. And we only look at alimony after the property has been divided. And again, you want to divide the property in a way to avoid alimony if possible. And you just go through those factors and try to set your position in a coherent manner get it before the court. I look at income and expense statements very closely. And I will tell you, and I stress this to lawyers, please make your income and expense statements accurate as you can. Don't load it up and, ask for the moon. That's not what you do. You want to be realistic. Okay. And I will go through, I will look at the need, and sometimes I will cut out amounts or adjust amounts on an income and expense statement. And then I'll go over to the potential obligor's income and expense statement, and I'll do the same thing. What's it going to cost to move into an apartment or rent a condo or something of that nature? What does the obligor have the ability to pay towards that? What's it going to cost for utilities? What does the obligor have the ability to contribute towards that? And you just go down the list, and sometimes you can make it work, sometimes you can't, and then you just have to do the best you can with what you have. And I think sometimes litigants, forget when one party moves out, it automatically increases the monthly living expenses, often by 50%. So it's always cheaper for two people to live together than it is to live apart. And that's the problem we have often in temporary support situation. And you look at it the same way. I'm one that if you put it down in a sworn income and expense statement and everything's reasonable, I don't need to hear a lot of testimony about the expenses if they're on the income and expense statement. That speaks for itself. And I can get to the heart of a temporary matter by the sworn income and expense statements. And, under the statute, we can decide temporary support just on income and expense statements. But that's kind of a snapshot of what I look at in an award of alimony. And you can have two judges, take, for instance, me and Judge Robinson. We will probably both, under the same scenario, get to the same type of alimony, but the duration and the amount may be different. And neither one of us are wrong in the interpretation of the statute because we have so much discretion. So no two judges are always going to hit the same amount of alimony. Hopefully they'll meet the same type, maybe the same in the duration, but not the same amount. I think you have watched me enough, Steph, over the years where you kind of know what I'm going to do. And you can relay that in a judicial settlement conference. And, you hope that people will listen because there's kind of as Judge Robinson would say, method to your madness. And so that's it. But I'd love to take questions on what I just discussed.
Yeah, let me ask this question. I had this in a judicial settlement conference this week where an attorney for her client wanted the husband to pay an alimony and solido amount, essentially that was going to come from his separate property. And obviously the court does look at each party's separate property at the conclusion of the divorce and an alimony analysis as well. But tell me a little bit how that separate property actually truly comes into play.
Well, one, you're not supposed to be able to touch separate property, but you can consider it in an award of alimony. You can consider it in an award of child support. And, if the separate property is income producing, then it's really easy to consider. If it's rental property, if it's regular investment income, things of that nature, it's really, you can determine the finite amount that it is paying on a monthly or weekly or semi-annual basis. And, you can consider it and, you can order the alimony paid in a certain amount. And it doesn't have to come out of that. It can come out of earned income, that from a job. You're only considering the separate property in the overall scheme and looking at the obligor's ability to pay. That's something that a lot of lawyers forget about. But always look at that separate property, see what's out there. And let me say, it may be just a corpus of money, but you look at that income that money is producing or should be producing. I think you could impute a reasonable amount on, say, $1 million sitting in a savings account. Well, what are you getting on a savings account now? I don't know, probably less than 1%. But if you invested that $1 million in a fairly conservative way, you should be getting a return in this economy of at least 5%. So that's something that the court can use as a tool in determining the obligor's ability to pay.
And to your point that you made a moment ago, so there are times in judicial settlement conferences where I want to consult with a judge about an issue that may be a sticking point, and he might help move the needle. And so I went and talked to Judge Robinson about that issue. And so
I'm
you and
sorry.
I haven't even talked about this.
I'm so sorry you had to talk to.
Well, I can't talk to you about it, So
No, you can't.
I went and talked to Judge Robinson. Judge McClendon wasn't available, so I had to go to Judge Robinson. So, but no, and you and I haven't even talked about this, but that's exactly, what he laid out in terms of, you can't touch that. If it's income producing or something of that nature, absolutely, you can consider that in terms of resources for alimony. But the separate property itself, which was a house that they wanted to take a mortgage against, or they wanted the husband to take out a mortgage against to pay the wife, you can't touch that asset. And so we were able to get the case resolved with some direction and input from Judge Robinson. So that was really helpful. How often, we typically think traditionally of as alimony being awarded to a wife, right? How often do you award alimony to a male or a husband?
Well, I mean, I approved a marital dissolution agreement just this week that had an award of alimony to a husband. I mean, you look at it the same way. Back when I first started practicing, the law had not been gender neutral for very long. I believe the case was Orr versus Orr, and I believe it came out in the early 80s out of the United States Supreme Court that actually forced Tennessee to interpret that statute as gender neutral. And, I look at it the same way. It doesn't matter. And we're seeing more and more today, at this point. Had a case today where it was a post-divorce modification of a schedule, but the father is he lives with the partner out in Colorado, and she's a pediatrician. She's the breadwinner. He's the stay-at-home parent. And in that situation, you have to look at it the same way. And you'll often hear me say, what's good for the goose is good for the gander. And so we're seeing more and more of it in role reversals, and we're seeing more and more of men receiving alimony. I will tell you, though, I think we're probably seeing a lot less in alimony, particularly long-term alimony, now than we did 20 years ago. Mm-hmm. And I believe that's because that we have more two-income families. And, going back to a determination of primary residential parent, you may have both parents assuming equal responsibility for a child or children. And, maybe they have multiple children and one parent has to go here with one or more, and the other parent has to go somewhere else with one or more. And so, when you're seeing that, both spouses are working, there's just not as much need for any type of alimony. So I have to say, I think we're seeing a lot less alimony than we did 20 years ago in the forms that existed then. And the one I see now more than any other form by far is transitional.
Mhm. So we've got a question from Ryan Davis, actually. And that question is, how often do you see obligor spouses filing petitions to modify transitional alimony? The statute seems to say that it's non-modifiable unless the parties agree it can be modified or unless the recipient is living with a third party post-divorce.
You know, I don't really recall seeing in the recent past a modification of transitional alimony, and really for it to be modified, kind of in an easier way. The parties have had to agree to the modification. The terms of the modification itself. Remember on the modification, the live-in love, the cohabitation statute, live-in lover statute, whatever you want to call it. That's a difficult statute to really get a modification of either transitional or in futuro alimony. And part of the reason is if there is an alimony recipient living with someone, particularly someone with whom they're romantically involved, you may file the petition, but then all of a sudden, the alimony recipient shoos the romantic partner out of the home. And maybe for the period of time that they were living together, from the time of the filing to the time that they moved out, you could get a modification there. But once they move out, your claim for a prospective modification is really gone. And, also, all that statute does is result in a burden shifting. There is a presumption that either the alimony recipient is, contributing to the support of the live-in romantic interest, or the romantic interest is contributing to the support of the alimony recipient. All you do is get, the presumption just shifts it. That spouse may be able to still show a continued need, may be able to rebut those presumptions. So that's really a tough statute, in my opinion, to modify under, particularly transitional, because it's usually shorter term. Mm-hmm. And, by the time you get through the discovery process and get a case ready to set for trial, the transitional term may have run.
When we're talking about modifying alimony, what is the court really looking for in modification cases?
Well, and let's set aside transitional alimony. Let's say it's a modification of rehabilitative or in futuro alimony. The standard really is a substantial and material change in circumstance, and that's not there's not a bright line test to determine what is substantial or material, and the court has to look at what is the substantial and material change in circumstance. It could be time. It could be an increase in need by the recipient spouse. It could be an increase in income by the obligor spouse. It could relate to medical needs of the recipient spouse or the medical condition of the obligor spouse, and that they can't work. And I'm trying right now I'm having a senior moment. I'm thinking about the retirement case, and the style of the case just is slipping my mind right now. But the Supreme Court in that case said that objectively reasonable retirement is in and of itself a basis to modify the alimony. And if the retirement is objectively reasonable, then excuse me, then the recipient spouse has to share, in theory, Bogan. Bogan versus Bogan is the case. It is the the recipient spouse has to share in the decreased ability of decreased income of the obligor spouse. And the question is, what is objectively reasonable? And you have to look at a totality of the circumstances. What may be objectively reasonable in one case may not be in the other case. My thought is, as a general rule, excuse me, that anybody over the age of 65 can probably meet that objectively reasonable standard. It may not be the case with somebody below that, or let's say around 55. Under some circumstances, maybe it is reasonable. Under others, it may not be reasonable. So short of retirement, though, you have to look at the substantial and material change in circumstance.
Lewis Williams has a great question. How often does a final transitional alimony or immaterial alimony award differ from the monthly pending-like obligation or amount that the court orders?
Generally, in most every case. Remember, the temporary support is to maintain the status quo. There's no hard and fast rules on that, other than to kind of keep the boat afloat until you get to final hearing. You may have a spouse, maybe a spouse is put out of the house by an order of protection or a restraining order. But you still have to provide for the remaining family in the home. You've got to protect any equity in the home. Maybe it's the largest asset, so we don't want anything to happen to that. In temporary support awards, sometimes we have to stretch the rubber band pretty tight from a financial standpoint. And generally, final hearing, it's not going to be that way. You may have child support, you may have some debt, and you may have alimony. That's kind of a worst case scenario. Maybe you're not going to have the debt, but you're going to have your ordinary reasonable living expenses. But you're not protecting an asset. You're not providing necessarily on your own for the entire family. When I say on your own, the obligor spouse providing for the family on their own. In a situation where you have a stay-at-home parent and go to work and bring home the money parent, by the time you get to final hearing, that stay-at-home parent should have made some steps towards getting a job or getting an education, or have a plan as to where they're going to go in the future. But most every case is going to be different. There's going to be a difference between the penalty lighty award and what the award is at final hearing.
What trends, if we can even call them that, are you seeing from the Court of Appeals or the Supreme Court as it relates to alimony? I know I say trends, if we can call it that, because it seems like it's all over the board. Obviously, we know there's a lot of discretion with alimony, but is there anything you're seeing more than not in terms of a trend?
You're right. It's all over the board. And again, we've got 12 judges on our Court of Appeals across the state, and they see things differently, just like a trial judge. Now, in theory, the Court of Appeals should not touch an alimony award unless there is a misapplication of the law or an abuse of discretion by the trial judge. These are one of the areas they defer to the trial judge. Probably the thing I see the most out of the Court of Appeals are remanding cases for insufficient findings of facts that justify the award of alimony. And remember back in, I believe it was July of 2010, soon after I took the bench, and was not aware this was going to happen, but the rules of civil procedure changed, which makes the trial judge responsible for sufficient findings of fact to back up their decision. Before that, the court could just rule from the bench and put the ruling down, and the Court of Appeals were really obligated to find a sufficient factual basis in the record. And this is something right now coming out of COVID that is taking a lot of time. Right now, with our obligation to make findings of facts and conclusions of law, but findings of facts mainly. When I walk out of the courtroom, particularly after a multi-day trial, I'm only 1/3 to halfway finished. I've got to write that opinion, and I don't know how to write a short opinion. Okay, I'm trying to learn, but I don't know how to write a short opinion. So it's we're getting backed up right now. I've got 4 things under advisement, and as you and I've discussed, we're going to have to work out a plan in the future to kind of learn how to deal with this and get these decisions out. But that's really the only trend I see, is the Court of Appeals sending cases back because judges have not made adequate findings of fact. And let me say, I don't disagree with them doing that.
Mm-hmm. Yeah. That would make sense. Something to support what the position is.
Yeah, not that they're concerned with my opinion, but
you never know. But yeah, I do want to talk a little bit about it. That and this is going off the alimony, but having an insider's view, there is a lot that goes on behind the scenes, more so than what people see on the bench. So if you have a 3-day trial like you just finished today, how many hours, let's say, will you need to put into that opinion? And this was a case with really a parenting plan modification, not even a change of custody, just a modification of the parenting time. So you had 3 days of trial, which was roughly, maybe, because today wasn't a full day, maybe you had, I don't know, maybe 10, 15 hours, maybe 16 hours.
Yeah.
All right.
Yeah. And it's going to really depend a lot on how complex the case is. If I've got a 3-day trial and it involves a divorce case where all issues go, I have to decide, then it's going to take a lot longer than like the case that I had today. The case I've got today, I will probably have to spend 10 to 12 hours on that to get it ready to be released. And I won't be doing a memorandum opinion on that. I'll get it ready and announce it. But, I've got to go through the factors, make the findings. I got to make credibility findings. I've got to put the testimony together. And so, yeah, probably 10 to 12 hours, maybe a little less than that. But again, if it were a 3-day trial where you've got to address grounds, division of property, alimony, maybe custody or visitation, and attorney's fees and court costs, you're probably looking at 20 hours to get something together. And Judge Robinson and I only have Monday mornings and Thursday afternoons to work on these decisions. So we're spending a lot of time on the weekends doing our decisions. And Philip comes into the office regularly on every weekend. I will work at home. I'm sitting in my home office right now. I can get more done here than I can at the office. But it's going to be really tough going into the fall and getting through the fall and into the winter. Coming out of the pandemic, as everyone is aware, we're backed up. I've got cases set through the end of the year, and we've never had that issue. Judge Robinson's in the same position. We've never had that area. We've had a great docket management plan and case management plan, but you know, the pandemic has thrown it all on us. And I will tell you, it seems like fewer cases are settling right now. People are wanting to try their cases, and maybe this is a a post-COVID trend. I don't know. I hope not, but it's going to be tough for us to get all of these decisions out on a timely basis and continue to hear cases and then campaign, because we're in a re-election cycle right now. Yeah. So, and I do want to announce to everyone here in the Zoom room, I am running for re-election. I would love to have your support, and I would love to have, more importantly, your vote. So it's my understanding Judge Robinson is running also. I wish he was here to announce, but he and I see Judge McClendon. Judge McClendon, would you like to tell us what your decision is on 2022?
My decision is absolutely, I would be honored and thrilled to have another 8 years. So I seek everyone's support, their vote. I'm listening in. I rarely get to sit in your court, but when I do, I always enjoy it, and your staff's fabulous. So I appreciate your vote, and I appreciate the shout out. Thank you.
Well, let me say, I'm running again so I can work another 8 years with Judge McClendon and Judge Robinson.
And I'm supporting Judge Smith in running again so I can work another 8 years with Judge Smith.
Thank you, Phil.
Out of the way. People are like, are you running? Stephanie is not running. So you can squash that rumor. I'm not running. Judge Robinson and Judge Smith are running. So, well, thank you. It's 7 o'clock. We will be back again on the 18th of August. And also on the 12th of August, the domestic violence seminar that will take place at the Justice A. Birch building, August the 12th, I think at 4 or 4:30 in the afternoon. So join us for both of those events at 4. Join us for both of those events. Thank you for being here. This is recorded. It'll be on Judge Smith's Facebook page. So this will be a really good, this was a good episode to really go back and digest a lot of the good information that I think Judge Smith gave us all. So thank you all for being here. Have a good evening. Good night.